correspondence. You can have up to 10 minutes also. And you identify yourselves also.
Lieutenant Christopher Woon from the Police Legal Division. Sergeant Anthony Petros from the Police Division. Good afternoon, task force members. Mr. Garza, I welcome your concerns and issues, and I thank you for bringing them here today. Now, the first issue that was brought up regarding number 14004. This was received at Police Legal on September 23rd, and in essence, this IDR compiled of several requests. The first request was regarding documents, regarding emails, correspondence, logs, notes of conversation regarding the 5150 event. The second issue was regarding the videos, pictures, and audio recordings from Northern Police Station that he requested as well. The third request was regarding documents regarding charge slips, police incident reports regarding the 5150 detention. The next request was regarding name badge number of the officer regarding the being handcuffed and escorted by police car to the PBS. The last request under this IDR was for paperwork sent, received, email, transmitted to all agencies. All requests, paperwork received, email to all other agencies. Now, Ms. Conifrey is a police representative regarding this incident, and since this is an IDR that was sent on the 23rd, she responded appropriately also on that date, on the 23rd, and responded in an email to Mr. Garza, and responded with the response saying that the report that he requested was exempt from disclosure under 6254C of the Government Code, and then requested an extension to provide other further detail regarding the circumstances of his request. Three days later, on September 26th, Ms. Conifrey sent an email providing information to Mr. Garza on a rolling basis, provided information such as the officer's name that he requested and the star number. Also provided Mr. Garza the information regarding the video from Northern Police Station. And the response that Ms. Conifrey provided to Mr. Garza was that it was not taped. Her Captain Geckering from Northern Station, and she contacted the captain there, providing due diligence and research this question for Mr. Garza, and found out that there wasn't videotape, it was in real time only. And the video that Mr. Garza was inquiring about an officer taping the incident, that video was deleted, so there was no responsive documents for Mr. Garza regarding that. And regarding the report that Mr. Garza was inquiring about regarding 5150, that is exempt under disclosure under 254C of the Government Code. Now with that, I want to explain the circumstances with that. So Mr. Garza requested the incident report for that mental health detention incident. On October 1st, which is 8 days later from the initial request that Mr. Garza requested this detention report, we ultimately gave a response back to Mr. Garza stating that it was exempt from disclosure under 6254C. However, he could still obtain that report by going to the records division downstairs at room 475, provide Mr. Garza the contact telephone number, the address where he could do that, and even provided Mr. Garza with the proper procedure how to get it with an attached request form. So Mr. Garza did give information if he wanted to go to that location to provide in that fashion. If we were to provide it in circumstance such as a PRA request, a Public Records Act request, and Sunshine request, then under 6254.5 of the Government Code, we would have to give this information to other requesters in the future. So in order to protect his privacy rights and at the same time still be able to provide him this information that we requested, we directed it into the proper entity to actually get it without violating his rights in that fashion. Now, regarding complaint number 14003, regarding the October 24th IDR, this, you have to understand that between September 26th and October 24th of last year, there was numerous conversations or emails sent back and forth from Ms. Comfrey and Mr. Garza requesting various information. And on this IDR dated on October 24th, most, if not all, the responses were given to him prior to that event already. But to ensure that he received this information and he understood this information, Ms. Comfrey also provided to him, again, in a separate email on October 25th, which is the day after the IDR was sent. Specifically, regarding the request that he asked for, was regarding the videos, again, regarding the Northern Police Station. And on September 26th at 1:50 p.m. in the afternoon, Ms. Comfrey sent a response back to him regarding that video was not taped, and we had no responsive documents in that sense for him, provided the officer's name and star number. Also, regarding how to get regarding the report is exempt from disclosure. However, on October 1st, she already let him know to get that report. He would, the proper procedure would go down to the records room to get that. Regarding another request regarding the video retention data from North Station regarding the policies and procedures regarding that, Ms. Comfrey directed Mr. Garza to go to contact the city IT department and provide the phone number from them. Ms. Comfrey researched that item and discovered through Captain McEachern that that was the proper venue to contact and to research. Regarding the issue that Ms. Garza had regarding ADA Disability Representative Title II, regarding policies, position, filling it from the San Francisco Police Department, Ms. Comfrey answered that on October 16th at 1:57 p.m., stating in essence that this representative that we had for the police department was for in-house members of the police department. And she also provided a document that outlined that process and procedure as well. However, our representative, in an effort to further assist Mr. Garza, Ms. Penny Tsai also contacted Mr. Garza on the telephone that same day and also memorialized that in an email stating that she referred Mr. Garza to the mayor's office on disability, providing a phone number, location where he could research that issue as well. Like I said, on the day after of this incident of the October 24th, the IDR, Ms. Comfrey also sent an IDR representing that information that he requested to ensure that he received that information. But that's all documented in the email as well, dated on October 25th at 1:52 p.m., where in essence she broke down the email to a question and response, provided him with the necessary responses. Regarding another request that Mr. Garza made, stating that he wanted a copy of the incorrect findings report, which is thorough diligent investigation, the incorrect response and incorrect information. That was unclear, and this is Comfrey contacted, emailed Mr. Garza regarding that, and asked him to clarify that request, and also further provided him information that that report still, if he was referring to that report, was exempt from disclosure. However, if you need to get a copy of it, you go down to the records room to get that. Now, in summary, I want to say that the police department wants to be as transparent as possible, provide all the necessary information that the public needs. If they want any information that we'll be able to provide them as permitted by law, that is our obligation to do so, and we'll be happy to do so in that fashion. Regarding the circumstance regarding Mr. Garza, I believe that Ms. Comfrey acted within the provisions that of the Sunshine Ordinance and the Public Records Act, and she acted with due diligence to research these issues for him, provide him a response. If we didn't have a responsive document for him, Ms. Comfrey either stated to him that we didn't have that document or referred him to the appropriate venue to gather that information that he requested. In conclusion, I want to say that we appreciate Mr. Garza's concerns and issues, and we want to let him know that we respect to his concerns regarding what he would like from the police department. However, I feel that we provided responsive documents that we had, and we acted within the provisions of the Sunshine Ordinance and the Public Records Act. Thank you.
Thank you, Lieutenant. What was your last name? Was it Woon?
O-W-O-O-N.
Okay, don't go too far. So, do I have any members of the public who would like to introduce facts or evidence in support of the respondent? Okay, seeing none, then I'm going to open it up to my task force members. I'm going to start with member Neat.
Lieutenant Wooten, please. You stated that Ms. Conifrey responded to Mr. Garza on the same day that she received the communication. However, according to the records we have, she was not the original recipient of that communication. The communication was originally sent to Chief Sir and was not forwarded to Ms. Conifrey until 2 days after the initial receipt of the request. I'd like to know why that delay in number one, why the delay in forwarding the request, and number two, why the delay in responding to Mr. Garza.
Are you referring to complaint number 14004, sir?
I am referring to the, I'm not sure which serial number you're referring to, but Mr. Garza's original IDR, immediate disclosure request, was sent to Chief Sir on September 21st, 2013, I believe, and he did not receive a response until 2 days later. Why that delay?
I understand, sir. And the response that I have for you in that, September 21st, 2013, at 7:23 p.m. was the original IDR that was sent to Chief Sir. That is a Saturday weekend, and we received it on the 23rd, which is a Monday, sir.
Thank you. Another question regarding your introduction of the 6254C exemption. My reading of 6254C is that the record should not be released unless, if it would constitute an unwarranted invasion of personal privacy. Now, the record that Mr. Garza was requesting was about himself. It was about, I believe, had to do with his own medical circumstances and the circumstances of his detention. How does somebody how does the release of a record about, to the requester, about the requester, constitute an unwarranted invasion of personal privacy?
I'd like to explain that. So, Mr. Garza requested the incident report regarding his mental health detention report. Under 6254C, that I understand, is that records that are medical records, personal, would constitute unwarranted invasion of privacy if we were to release to other parties. So, for example, if we were to release it to Mr. Garza under the Public Records Act and Sunshine Ordinance, for him to give that report to him under PRA and Sunshine Ordinance, then we must release that report to other individuals in the future regarding that report under 6254.5 of the Government Code. So in essence, once we release it to one person, even though it may be the person that filed the report, we're obligated to release that report under the Sunshine and PRA to other individuals as well that request it in the future. Therefore, to protect his privacy rights and to satisfy his request to obtain the report, we directed Mr. Garza to obtain the report through the Police Records Unit, which is the policy of the police department, in that fashion, so that his rights would be protected.
How are his rights any less protected if he gets them from the police records unit? than if he gets them from your office or from Chief Sir's office? Are they any less protected?
Well, if he could get the report through the records division downstairs in room 475. Now, if he got through the Public Records Act Sunshine Ordinance, then if there's another request in the future from an individual requesting that same report, we must give that report to that requester,
You're not answering my question.
unless your question
My
is.
question is, you said you directed him to the police records unit with that request. You suggest he channel that request through the police records unit. How is his privacy any less protected if he gets them from the police records unit than if he gets them from the office of Chief Sir?
Well, my explanation once again is that once he gets the report from the records unit, they provide it in that fashion. If we were to release this report due to PRA Sunshine, another party in the future that may request this information, we must provide that information to that party in the future. Now, if Mr. Garza received this report through the records division, on our hand, and another individual requests the same report, the records division would most likely deny that request. Though, therefore, in essence, his privacy would be protected because the party asking for that report and going through the records room, they would, in essence, would not get that report.
When you relayed that reasoning to Mr. Garza, which I assume you did you ask him if he felt his privacy would be unduly violated if the records were released?
I have not spoken to Mr. Garza personally. This, sorry,
Well, whomever he dealt with then.
it was probably Ms. Comfrey.
Okay, did she, do you happen to know, or maybe Mr. Garza could answer this, did Ms. Conifrey ask Mr. Garza if he felt that the release of those records would unduly violate his privacy?
I'm sorry, is that a question for me?
Question for either one of you.
I don't have an answer, just
If Ms. Conifrey is here, perhaps she could
Ms.
answer.
Comfrey is not here, so.
Okay, perhaps Mr. Garza could answer that then.
Thank you, sir. What was the question again, please?
Question, you were told that there may be an undue violation of your privacy if the records were released to you, the records you had requested were released to you, because then if they were released to you from Chief Sir's office, anybody else who came in to Chief Sir's office could then ask for those records, and Chief Sir's office would be required under both the Public Records Act and the Sunshine Ordinance to release those records to anyone else who wants. So my question is, were you informed of this concern about your privacy, and if so, what was your response?
No. As a matter of fact, when I read the denial, I was led to believe that she was denying me those records on the fact that it was the officer's privacy that she was concerned about, not mine. Now, the interesting part is, this was for an IDR. Yes, I did go ahead and follow through with what she said, but that process took another week and a half, maybe 2 weeks before I even got those records. In addition, the information that is on the police incident report is the officer's take. It has nothing handwritten from me. It's simply what his take was on falsely, illegally 5150 me, and that's why I wanted it. So when I requested that, they said privacy, and I was assuming she was meaning that I couldn't get it because of the officer, because basically I felt that was what she was trying to tell me about, the same thing about, not being able to tell me who the officer was, and then when she came back and said, on the 19th, which of course was the incorrect date, she gave me the officer's name and everything else. So I was never broached with, about an invasion of my privacy. I have no qualms about my privacy being invaded. The only qualms I have is, when it comes to my medical records and their privacy being invaded because of, a HIPAA regulation. This was not a medical form. This was simply, the arrest incident report that I was trying to get so that I could see how the officer had framed, had, what's the word I want to use, had set this up so that, I could find where the discrepancies were and everything else. Now, again, let me once again repeat for the record, that I did follow up on what she told me, even though it was incorrect and late, and it still took another, I would imagine, 10 days. I'd have to go back and look. Once again, defeating the purpose of an IDR. Now remember, these IDRs were in September and October of 2013. It is now May. May. And IDRs are supposed to be used so that people can get what they need to represent themselves effectively against timelines. If, for example, we have a 6-month timeline deadline to file something. Well, it's been well over 6 months, and I still don't have what I need when I requested an IDR.
Mr. Garza, question, just to follow up on
Chris, hold up, I've already got an order.
So that was my answer, Mr. Nee. I hope it answers what you asked. If not, ask me something more specific, and I'll be happy to answer it for you.
Well, I did have another question then for Lieutenant Bloom.
If I may respond to Mr. Garza's response.
Yeah, well, Mr. Garza has said that your refusal, your concern about privacy was for the privacy of the arresting officer, not his own privacy. Is that correct?
I don't know regarding that, sir, but what I can tell you is that on September the 23rd, Ms. Confer did send an email back to Mr. Garza stating the exemption that the report is being exempted under 6254C due to being a medical personnel.
Okay. We're gonna go Member Highland, Member David, and Member Pilbell.
Mr. Garza, question for you. So, September 23rd letter quoted the 6454C exemption. She then sent you another letter on October 1st saying that information was available at CISD and gave you a report number.
At where? I'm sorry?
At CISD.
The criminal, downstairs.
Yes.
Yes. And that was when did you say again?
October 1st. She followed
So
up.
for an IDR that was supposed to have been filled within 24 hours,
Let me ask my question.
Please.
Did you then go down and get that information, and do you now have that information?
I believe I told Mr. Nee that I jumped through her hoop, and that took another 10 days or 15 days. I don't remember. I'd have to go back and look at my records. The videos are on YouTube of me going down there and requesting everything, and when I did go back and receive it. So everything is on YouTube, so that people will not say.
We're going to debate whether there was a timeliness issue there. That's not what I'm arguing with you. I'm just asking you.
I wasn't arguing, sir.
Were you able to get the information you wanted after that second communication, October 1st?
Yes, not timely.
Thank you.
Member David? Good. Member Pilbell?
All right, so there are a number of issues here. Let me see if I can sort this out a little bit. Let me start with Lieutenant Moon. So, if I understand correctly, the videos that were alleged, there are no videos in the possession of the police department, and so you can't provide any videos because there aren't any videos available. Is that correct?
Correct.
Okay. And with respect to the other requests of Mr. Garza, you believe that those were responded to in a timely manner, and that all the information that you had was provided except for the information that you withheld under 6254C. Am I capturing too much there?
The 6254C, I understand, is the incident report. That information we referred into the records unit so that he could obtain that information.
Right, but you didn't provide it. Okay.
So he did
But
get that.
everything else other than that information he was looking for, you believe was provided?
Either it was non-responsive, either it was provided to him, he was referred to a different unit to have this information, he did it to him.
Okay. And I think I understand what your exchange earlier with Member Nee about a record, and once it becomes public, it's public for everyone, and so you were suggesting that he obtained it in a different manner so that it wasn't public, it's subject to the Sunshine Ordinance, which would then make it public to everyone. Is that?
Yes, in
Okay.
essence, we wanted him to have that report, but if he went to the proper channels to protect his privacy right, because we're looking out for him,
Right.
so that he could obtain this information.
And protecting the third-party privacy rights of individuals is something that we do as a government, and that's the way that works.
I really think that's important to state. And also regarding the initial September 23rd event where Ms. Confer responded back to Mr. Garza where she invoked the extension.
She did.
And- I'm sorry?
She did.
She invoked an extension on September 23rd at the 1:16 p.m. There was the response back to Mr. Garza where he exempted, she exempted the disclosure from the report and also invoked an extension under 6253C. And the reasoning for that, I want to elaborate a little further regarding that, is that the request that Mr. Garza was not a simple, readily accessible, easily answerable question to provide to Mr. Garza. In essence, he asked for example, video from Northern Police Station, which is a separate field facility, different.
I understand. I would say in summary that her response of September 23rd on 116 could have been more detailed as to the reasons for the extension. That doesn't talk about field facilities. I mean, that is another reason for an extension, but that wasn't covered in her email. But aside from that, was her subsequent response, and it's hard to tell from all the various email chains, if that was provided on a timely basis within 14 days after the extension.
Yeah, so the 6253C1, I believe it does state the fact that it's a separate field facility with a different division of the police department, so located at a completely different address. So Ms. Confer, you need to do some due diligence and then...
Yeah, no, I'm not questioning that.
...to provide an accurate response to Mr. Garza. So that was on September 23rd at 1:16 p.m. where she invoked that extension, and on a rolling basis, Ms. Confer provided information to Mr. Garza. The next response back after September 23rd was September 26th, 3 days after the 23rd, provided further information regarding the video, regarding the officer's information, and further regarding the video, I believe, as well. And the next event after that is October 1st. October 1st was the subsequent email stating how he could get the report, which is 8 days from the 23rd, if we were to even consider that.
Which is within 14 days.
Within 10 days and 14 days of the extension.
Okay, so just to try to conclude here, what is the normal process by which someone can request and receive a police report? Can you just cover that for a moment?
Yes, so if a person requests an incident report, it's our policy to have that person to either come down to the Police Records Division in 475 E50 Bryan Street, or they could request it also through a request form. You fill out that information, mail it in, and then you'll be able to get that report, considering there's not any exceptions, whether it be medical records that you're not involved with and such, so it has a complete outline as well.
Okay, so that form, which was in our packet somewhere, and I assume is on your website and generally available.
Yes.
I'm just having a problem, maybe you can help me with this. How do you square that form and its particulars with the Sunshine Ordinance? It seems to me that in general terms, a police report is a public record. It may or may not be subject to disclosure depending on the particulars, but the report itself is a public record. So if someone just sends you a letter and says, hey, I'm looking for police report number 123456789 or a CAD item number, whatever, however you structure that, please send it to the following address, I'm happy to pay the fee, or whatever, right? It has that information. Do they still need to fill out the form? And how does that form sort of square with the ordinance?
What I understand is that if a person requests an incident report, they fill out the paperwork, and then depending upon what report it is, for example, let's say it's a mental health attention report, that report will not be released to everybody regarding that circumstance, because once again, like we described, it's going to be under one invasion of privacy on the person that is detained. So that specific person that was requesting it or the officer actually filled that request needs to find out who this person is. It's not the person that's requesting it. They may or not release that information. And it depends, like I said, what kind of report it is. If it's a simple report regarding found property and there's no crime that the right to privacy, and that may report may be released to other parties as well. There is protocol regarding that, and it depends upon the circumstance of what kind of report it is.
And is that protocol in writing anywhere?
I don't know exactly that.
Okay. I'm not sure that I want to pursue this further. I think that where I'm at with this, if there was it seems like there's no dispute that there is an incident report. And I'm not sure, I'll ask Mr. Garza in a moment, if he actually finally received it. Did you consider in responding to his request whether you could release a redacted version of the report to have some of the particulars but without any information that you considered an unwarranted invasion of privacy?
I considered that, and the issue that I have is that our policy forbids releasing the name and address of people involved in, say, a medical record regarding say, mental health detention. Now, we must consider also in a police report or a medical record report, such as mental health detention report, regarding other issues as well, such as medication that may be taken.
Understood, but if that could all be redacted, again, we haven't seen the report, so I don't know what's in it. I mean, at some point, I think I'm also struggling with whether what you're calling a medical detention report, is that the term that you use?
Is that's a 5150 Welfare Institutions Code.
Understood. If that's the same as a police incident report, and if in fact, seems like it's not, but I don't know, and whether this sort of mental health report is actually a medical file within the meaning of 6254C, or if it's, you know, in this case, a particular type of police incident report.
I can answer that. So, a mental health detention report, incident report, is a police report, and it attached to it as well, or part of the process of that report, has a state form, which is the mental health detention report. So you got the incident report, police report, plus you have another state form regarding the circumstances of that detention. So in the incident report, I would be surprised if there is confidential information regarding the person being detained, such as medication being detained, circumstances of that person being detained, and also that state form where an officer fills out to have that individual being detained. Personal confidential information, medical record information would be on that as well. I would be surprised if it's commonly placed on it.
So do you know if the Welfare and Institutions Code makes that particular report, the detention report itself, a confidential record under state law?
I'm not sure.
Have you, City Attorney Cola, you know anything about that?
Sorry?
Do you know anything about that?
Could you repeat that one?
If the Welfare and Institutions Code makes that particular form, the mental health detention report, a confidential record under state law?
I'm not familiar off the top of my head with the Welfare and Institutions Code, but generally what I would say here is it's, you could just use a reasonable person standard to determine whether or not there's a privacy exemption in a document.
Right, no, I understand the privacy
So-
interests generally.
In general, the task force might want to consider whether disclosure of the information would compromise substantial privacy interests, and must determine whether the potential harm to the privacy interest from disclosure outweigh the public interest in disclosure.
Understood. So, thank you. So back to my question about the redaction. Did you say that you considered redaction of the incident report or the mental health attached report?
Well, this was I wasn't at this unit at this time. The incident on
Did Ms. Conifrey or whoever was reviewing, somebody presumably looked at the report and said, we can't release this to this person, period. Did that person consider redaction of portions of the report and releasing a redacted version of that report?
I can't speak for Ms. Conifrey regarding what she thought. However, what I stated to you before that I thought about doing that, there's a lot of complications regarding that because of the numerous things that may be on that report, such as, like I said, medication, other issues regarding his circumstances of why he was detained in the first place. So it may not be like a simple procedure where you just black out boxes. We're talking about stuff that.
Oh, it could be a heavily redacted report.
I understand that, but I'm not a doctor to analyze that regarding condition of a person that is detained taking possible medication for a condition that they may or may not be suffering.
Why don't I defer with?
I just have one quick question.
Yes.
So Lieutenant Moon, did you say that there is no written policy, or that you're not aware of a written policy at the police department regarding?
I'm not sure of a specific policy regarding, is it redacting?
No, about this whole, the release of, I want to make sure I'm getting 5150 reports. Am I saying that correctly?
Mental health detention report?
Yes, is there a written policy that explains what you have just come before us and explained that you don't release it because it is in the interest of one's own privacy? Is that policy written anywhere?
There is policy stating regarding information that you can release and can't release on police reports, such as name, addresses from medical records regarding mental health detention reports. We can't release that information. But as I stated before, to get that information, there is a protocol that we do here in the police department, which is direct, which we do direct.
Right, I have no issue with the protocol at all, but my question is that protocol available to the public to read, that this is the protocol, the way that the police department deals with these
I'm not
issues?
sure about that.
Okay, well, I would, if it's not, or if you're not sure, I would highly encourage the police department to make that, to have written protocol for that, okay?
And if it is available, we'd like to see it.
Yes.
Member Oka?
Yes, thank you. Lieutenant, everything that I've heard so far makes sense, except that Mr. Garza here has said that he didn't mind his medical record being released. He said that right here. So why was he not given his own records? I would have done that immediately. They're his records.
Understood, sir. The response I have to that is that I have no response from Mr. Garza saying that it's okay to release the information in that fashion. And once again, we as a police department want to be as transparent as possible, but yet we have to protect his privacy rights. So if we were to release that incident report, that mental health detention report under the Public Records Act, Sunshine Ordinance, then we must release that report to everybody else that requested it. Therefore, to protect his rights, we directed him to go to the records room, whereby we could satisfy his request to get that report and not violate privacy rights in the future if someone else requested it.
May I ask Mr. Garza?
Don't go too far, Lieutenant.
Go ahead, sir, please.
You stated that you were not informed that that was the reason that you were being renamed?
That is correct. In addition, I want you to know that everything that's been said by this officer has been a red herring. Because, for example, I was illegally 5150. The incident report, there is a 5150 manual on the police website. The 5150 was not valid. I was released within 2 hours. So to claim that, they're so concerned about my privacy and my medical condition when it wasn't even a valid 5150, which is why I'm trying to get these records to show that this is what the police department does to people instead of trying to help them, because I'm here trying to follow up on my medical care, so they'll bully and intimidate me by falsely 5150ing me. Oh, and by the way, we don't have the videos. Oh, and while we're there, we don't have the policies that regard these videos.
Hold on a second.
But we do have the policies that regard, the exemption. Isn't that amazing?
Is your question being answered? I just want to stay on what your question was and get the
That's
answer.
all I needed to know.
Okay, thank you.
So that is my point. You're being misled.
Okay. Come on back, Lieutenant. Anybody else got any? What I'm getting out of this, and I spent hours going through this today, is the thing that struck me as a little odd is that I want my own medical record. You're saying, no, I can't give it to you, but you can get it over here, right? You pointed our complainant over to another department or another group. Because what I'm getting on this is that if you release it, then boom, it's public and anybody can have that. And I get that. I wouldn't want my records being out there. But you didn't say no. You said, no, not from me, but from these people over here. I'm ridiculously oversimplifying this, but am I getting the gist of this? That those records were available through some other means?